Obviously, we know they're going to argue that it was an angry crowd, and that's why he couldn't intervene. But I like how the cases are being prosecuted. They're being prosecuted aggressively. I have to give credit to Keith Ellison and the Minnesota Attorney General's office for pursuing these cases. They are righteous cases. They are not easy cases. But the facts for both King, Lane, and Tao are going to be a lot more challenging. So I want to caution folks, I don't think they're going to be as quick as guilty verdicts as we saw in Derek Chauvin.
I agree with you. They will not be as quick, and some of them might actually get acquitted. It sounds like if the state didn't think that it was important enough, or they didn't think that it was something they needed to try quickly, I think that, in fact, we might see that we are getting some lesser as far as the conviction is concerned. So we'll see what happens.
At least arguably, from the defense perspective, a reason to lie, right? Their convictions have been dismissed or will be dismissed. They have something to gain, at least monetarily, from these civil suits. So, you know, what the defense is going to argue, look, these are a bunch of drug addicts. These are a bunch of criminals. You shouldn't trust them. Instead of this law enforcement officer who's dedicated his life to serving the public. Now, I don't think it's a winning argument because of the sheer weight of the evidence and the number of witnesses that we have, but this was what we expected in cross-examination and what we've seen time and time again from the defense. What I like what the state did is to get out ahead of this a little bit. Now that we've seen what the defense is going to do, they're getting these drug convictions out on direct, which is my preference when you're a prosecutor. You want to front that bad evidence and information for the jurors, not have it come out during cross.
That's true. As a federal prosecutor, a former federal prosecutor, you would know best how to handle that. What do you think is happening as far as the civil lawsuits are concerned? Is that something that the prosecutor should bring out on his direct, or is it better if the jury hears that on cross-examination? What's your thought?
Terry, I agree. Even with the civil lawsuits, you're talking to a former prosecutor now who's a civil plaintiff's attorney, so I handle these types of cases. And it's always fodder for cross-examination that this is just a money grab, right? This isn't about justice. This isn't about convicting Officer Wester. This is about getting money from the state, from the city, from you, the taxpayers, you jurors. So jurors can be skeptical of these civil claims. So it's a good area for cross-examination for the defense. So something that the state should front and explain why they're pursuing these types of civil claims, how their lives were turned upside down. And I think that sort of humanizes these folks because it wasn't just an arrest. It wasn't, you know, a misdemeanor or diversion or whatever they got. Their really lives were turned upside down because of these illegal searches, planting evidence, and convictions.
Yes, their lives were turned upside down. Some of them lost custody of their children. Others had to pay money. Some spent time in jail.
Just to humanize these people and just say they're innocent victims. They are not criminals. Because, I mean, all we heard was time after time, you know, their prior drug use, their prior drug convictions. And we know that Wester targeted these folks for that very reason. You know, these weren't folks with no criminal history. So what the state wanted to do is to show that these are real people. They've been victimized, and this is wrong. This is a violation of the oath that Wester took, a violation of the public trust. And this causes all of us, the general public, the law-abiding folks, not to trust law enforcement. It undermines our criminal justice system.
You know, you hit it right on the nail, the head on the nail. I mean, the point is, these are individuals who are entrusted, and you're supposed to be able to trust what they have to say and what they're doing. And it is really making it look bad for other police officers. And in fact, they should bring these civil charges if, in fact, it's all proven. So what do you think, let me ask you about Wester actually taking the stand. Do you think he'll be able to explain what his actions were, or do you think it's best that he not take the stand?
You know, it's tough. As a defense attorney, you know, you generally are going to be very cautious when your client wants to take the stand. Here's someone that has a history of pushing the limit. I would be concerned if I were his attorney. Here's someone that in his prior job engaged in sexual misconduct. You know, he had a relationship with a colleague, received nude pictures and disseminated them. Someone that has a history of having sexual relationships with a married woman. Someone who quit his job and resigned when he was being investigated. So this is someone that has an arrogance around him, and even how he was handling these cases, you know, when he was humming Christmas songs while he was searching the vehicle and planting the evidence, and just how he was dealing with these witnesses that have testified. he's someone that may think that he can get up there and convince this jury that he's a good person, he's honest, and these other folks are lying. But it's going to be a very, very risky proposition because I can see him come across as arrogant and not likable.
Interesting. I can tell you when I saw these videos, I'm thinking to myself, he's very nonchalant and he's trying to get these individuals to talk. So that to me was offensive. How does it compare to the searches that Wester himself did when he stopped these other individuals and he searched their vehicles?
Terry, I like the search except for the delay. You know in these defense cases as well as I do that the best defense is a good offense. And the best offense for a defense attorney is to say that it was a sloppy investigation. So we know from the cross-examination that the focus was the weeks that passed before they searched Wester's vehicle. Now, the search was fruitful for the state. You found, baggies and paraphernalia, things that you would not expect to find in a police officer's vehicle. And it was clear that that was the evidence that he was planting on suspects. So it was a good search. I just don't like the delay that elapsed before that search was conducted.
Exactly. There was apparently some confusion as to which agency should do the search, and I think he tries to explain that a little bit later. But it is interesting that they found the marijuana, they found syringes, they found some meth, and the fact that all of that matched what was in the cars of the individuals that Wester stopped. One of the things I also noticed is these items were not marked. Everything else in that trunk was marked. It was police equipment, and it was something that the police should have with them, except all of this was not evidence from other stops. What do you make of that?
I like it for the prosecution. Again, these aren't things that typically you would see in a police officer's vehicle. This is evidence. These are drugs. They should have been booked into evidence as such, and I think that's something that's going to be powerful evidence for the state, and one of the reasons Wester is convicted. I also like what this witness did with respect to bias and the reason and the motive why Wester may have engaged in all this conduct. That was a question we've all been asking, and I'm sure the jury's asking, like, why would someone do this? What do they have to gain? And the fact that he discussed his potential motivation to join the narcotics task force and be a plainclothes detective. So I think that was also very useful information we got from the prosecution yesterday.
Sloppy or lazy or didn't label things, or it could be that this evidence was evidence of planting all of this in the vehicles where he stopped these individuals. Do you think that he might argue that it wasn't that he was planting anything, he just failed to label some of this information?
Well, it'll have to be one of two arguments for Wester. Either A, the evidence was planted in his vehicle by someone else and he's being set up. How ironic would that be? Or B, that, these were drugs that were seized and paraphernalia that he just, like you said, was lazy and sloppy and didn't book into evidence like he should have. So I don't know what direction the defense is going to go in, but it really has to be one of those two. I think the latter argument, that it was sort of sloppy and lazy, it's a little bit more challenging because you have all these individual bags and paraphernalia and kind of all over the place, and it's precisely what was planted in the vehicles of these 100 or so folks. So it's consistent with that. It's going to be a tough argument for the defense to make. And again, I like what the state is doing here. They're closing strong with law enforcement witnesses, and that's the last sort of perception that the jury is going to have, instead of folks that have that checkered past in criminal history.
You're always reading my mind. Yes, they're closing with this individual. Did you think he was strong? He is a former lieutenant, and he didn't remember everything when he was on the stand. But do you think that he still came across as a good, credible, strong witness?
No, I think he was better than certainly the civilian witnesses, again, because of their criminal history. And even with the civilian witnesses, I like how it got progressively better. For instance, Miss Odom, we talked about that long video of her being transported to jail to be booked and everything. And during that time, like you said, Terry, before the break, you have Wester talking about, be careful about who you trust. And, people can plant things in your purse because the drugs were found in her purse. I liked how they closed with that particular witness as well. And the order is important. You always want to start strong and finish strong. And I think the state did in this case, and they had some of the more questionable witnesses in between.
You have prepared that witness a little better as it relates to when actually he investigated and looked into that trunk and how they kept the car and was it secure and who was going to do it. Was it going to be the criminal agency? Was it going to be internal affairs? Would you not have prepped that witness a little bit better?
Yes, Terry, poor prep by the prosecution, especially when you know the defense attorney was going to come after him on this very issue. He raised it on Monday. This witness is testifying on Wednesday. You had 2 full days. You got to do your job as a prosecutor. The day doesn't end when the jury goes home at 5 p.m. You got to prepare your witnesses for the next day. And you know that this is coming. You got to prep your witness, especially a law enforcement witness. He was not prepared. He did a poor job on this line of questioning. And really, frankly, it's the prosecutor's fault here.
I agree with that. Now, one thing I also was wondering about is, what's the policy here? I mean, was he supposed to tape the car up? It wasn't really clear to me with this examination whether or not he should have taped it, even though it could have been criminal or it might have still been in internal affairs. He made it seem like while it's in internal affairs, you don't tape things up. You only do that if it's criminal. But it does make sense to do it, and he did say in hindsight, well, maybe we should do it. But the jury's probably wondering, well, what is the policy? Do you think it was clear what the policy actually is?
Yeah, it was definitely taken for granted. The defense attorney assumed for this argument that regardless of whether it's an investigation or a criminal case, that he should have sealed the vehicle. This wasn't done. Again, taking for granted that this is the policy. It probably is a good practice regardless of whether it's just an investigation, because all investigations can ultimately end up being a criminal case. And you need to preserve the integrity of the evidence. You need to preserve that chain of custody, because we know that tampering with the evidence, or someone planting drugs, or someone accessing the vehicle and framing him, that's always going to be an issue. So this is something that should have been anticipated both during the investigation phase. It was a poor job by law enforcement, both in terms of sealing the vehicle, searching the vehicle, as well as during the direct and cross-examination of this particular witness.
No doubt about it. Now, Neama, we know that the state has rested. We know that the defense is going to start their case shortly. What should they do next? Who should they put on? Should they call witnesses back? Should they actually call Zachary Wester to the stand? What would the next move be if you were actually representing the defense at this point?
Well, every witness in this case, for some reason, has been subject to recall. So, anything's possible. What I would do if I were the defense, I wouldn't put Wester on the stand, because my concern would be opening the door. He's going to say something, and all these kind of collateral issues of misconduct will come in, because, cross-examination, really anything goes. And so far, the judge has kept most of that out, or certainly hasn't come in during the state's case in chief. I would put on law enforcement witnesses, if you have friendly ones, that would come in and testify that Wester has always been a dedicated law enforcement officer. His father was a cop. He's won all these awards, and just really sort of paint this picture of someone who is a law-abiding public servant who would never do anything like that. I think that's sort of the safe play. And another reason it's a safe play, whenever you're the defendant and testify, obviously the whole case will come down to your testimony. I have concerns about how he'll testify as a witness. But not just that. If you testify, you get up there, you perjure yourself, guess what? At sentencing, I know you're looking at approximately kind of a 20-year max under the Florida sentencing guidelines, even though the statutory max is higher. The judge may throw the book at you and punish you and impose a trial tax in a way that, he may not if Wester doesn't take the stand, doesn't perjure himself, and doesn't obstruct justice, and is still convicted.
That's true. Do you think that the jury, having listened to all of these witnesses that were put on the state's main case, do you think that they are feeling as though, look, you've really impacted the lives of so many people. Nothing you say when you get on the stand is going to exonerate you from doing that. Do you think that listening to these individuals really had an impact? And how can you, as a defense attorney, not you personally, but if you were the defense attorney, how can you deal with that issue, that sympathy factor?
You know, it is. These particular witnesses were very sympathetic. You know, their lives were turned completely upside down. Their families torn apart. Imagine losing your child because of someone planting evidence in your vehicle. So, you know, I understand the challenges that the defense has here. If I were arguing this case, I would just focus on the bias and what the defense has already done during cross-examination and just say, listen, this is about money. You know, this is about folks that don't want to accept responsibility. They want to get out of, you know, these criminal charges and cash out. That's what this is all about here, you know, and that's reasonable doubt, folks. They have every reason to lie, as opposed to putting Wester up there because, again, I don't know how much he's going to add to that defense argument. He's just going to come up there and deny everything that, you know, his attorney can do during closing argument. So I don't expect him to testify, but again, he's a little bit of, you know, someone who might not be controllable in terms of a witness. So he may insist on testifying. But if I were his attorney, I would try to keep him off the stand and try to convince one or two of those 6 jurors in Florida, remember it's only 6 because it's not a capital case down there, to hold out because they have favorable views of law enforcement.
Prosecutor, would you be upset if you saw this footage where he's humming a Christmas song as though this is such a nonchalant thing that he's doing? He's arresting someone. What's your thought on that?
Yeah, I do not like this at all. Even if this weren't a planting evidence case, that's the last thing you want to see as a prosecutor. You want someone that's taking his or her job seriously. And I used to prosecute narcotics cases, not possession, but trafficking as a federal prosecutor. And you know, people expect law enforcement to behave in a professional manner, not be singing while they're searching vehicles and making arrests. That's just inappropriate. And I think it's just going to be one additional thing that the jury is not going to like. You know, they're not going to like him because he's not turning his body camera on when he should have. He's turning it on after he finds the drugs, or not turning it on at all. He's not documenting the instances where he doesn't have full body camera footage, you know. And when he's arresting people, he's saying that you got to be careful about, you know, who you let access your vehicle. You know, he's basically telling them that, you know, it's offensive on so many levels, but highly offensive when he's blaming them for drugs being planted on them when he's the one responsible. So I think this kind of totality of the circumstances is going to paint a picture for this jury of someone that is not to be trusted, shouldn't be in a position of public trust and service. And that's why I expect a guilty verdict in this case.
I think you might be right about that. Listen, court is back in session. We know that the state has really rested, but their emotions. Let's take a listen to what they're doing.
We also have, you know, people that were arrested and charged with crimes, and nobody made any complaints or nobody made any challenges to it until after Mr. Wester was suspended by the sheriff's office. So as to the perjury, fabricating evidence, possession of controlled substance.
Do you think that this witness actually helped the prosecution here in terms of transferring some of that evidence from the defendant to the cars that he actually inspected?
I didn't think she was particularly helpful, but the prosecution had to put on a witness to explain the lack of evidence, right? There was, one of the questions was sort of the lack of DNA, lack of fingerprint testing. Again, the sort of sloppy examination, right? The sloppy investigation. So I think she did a sort of good job explaining why that evidence wasn't presented. And then she also had to explain the issue with the testing, both the field tests and the test and the lab test for these drugs, because they were entirely inconsistent. Sometimes they would come back positive. Sometimes they weren't positive. They were either inconclusive or negative, and Wester would say that they were positive, or in some instances they were just outright negative. So we needed someone like this to explain those issues to the jury, but I don't think it particularly advanced the ball or moved the case forward with respect to the actual charges against Wester, especially when they're going after Wester for the same issue, or they're attacking him on the body cam, saying that, you know, he didn't start it and run it the whole time. It started in the middle of the investigation or after the drugs were found, and now you have the state who's doing its own search, and, you know, you have a video here that should have probably been taken weeks ago when the search should have originally happened. It's starting and stopping. I don't like this for the prosecution. Again, you're just opening the door to reasonable doubt, and these are the types of things that defense attorneys, I'm sure, love because, again, they can go after the state for not doing their job and not doing it properly.
Absolutely.
Well, that's part of Wester's MO, right? He always smells marijuana. That gives him the probable cause to search the vehicle. He searches the vehicle, and lo and behold, it's not marijuana, it's actually methamphetamine or methamphetamine paraphernalia. So it's actually sort of good pattern evidence for the prosecution because it's quite common for him to start with the marijuana, get the PC or probable cause he needs to search the vehicle, or at least ask to search the vehicle and get consent, which he often does.
Police officer the right. I mean, unless the arrest has already occurred or there's some probable cause, do you think they should consent? Real quick.
No, you shouldn't consent. You shouldn't let officers search your vehicle unless you've been arrested, search incident to arrest, they have probable cause, which we discussed, or the vehicle is impounded. Those are really the three bases, plus consent that an officer can search your vehicle, but you shouldn't consent.
Very exciting, Neama. That motion was by the defense for an acquittal, basically saying that the prosecution did not basically bring all of the evidence and it wasn't beyond a reasonable doubt, and so the case should be dismissed outright at the end of the state's case. But the judge denied the motion, and he had some reservations about that racketeering charge, and it all had to do with whether or not this was an enterprise. He said he was leaning towards the fact that it was an enterprise, but he wants to see some case law. They have to have that Saturday by 5 so the judge can look at it. I think that's another thing juries don't understand, and probably most people watching these trials don't understand. You're really working 24/7 when you're on trial. But what did you think about the judge's decision as it related to the motion? Were you surprised?
Well, that's the great thing about the Law and Crime Network. You can see the inner workings of the courtroom that juries often can't. So, these motions for acquittal are routine at the end of the state's case. The defense will make it every time. So that was expected. But really, I love the argument about the Florida RICO statute. And as a former federal prosecutor, we love RICO, and the Florida statute is patterned after the federal one, which was its predecessor. So the defense made a few interesting arguments. Some were good and some were not so good. Start with the not so good. The first argument was that one individual can't be an enterprise. That's one of the requirements of any RICO statute. Well, under both the federal and the Florida definition, an individual can be sufficient for an enterprise. And really, that really kind of misses the point. The enterprise itself doesn't have to be a criminal enterprise. That's a common mistake, a common legal mistake. The only real requirement is that the individual, the racketeering acts, which are the unlawful acts, either benefit the organization or the individual is able to participate in the racketeering acts because of his position or her position in the organization. And that's the argument that really kind of the state tried to make or should have made, and that Wester here was able to do this unlawful activity by virtue of his position as a sheriff's deputy. It's not a requirement that the organization itself be a criminal enterprise like the mob or a cartel. That's not required. And in fact, the organization or the enterprise can either be a passive participant or even a victim of the criminal activity, which was the case here. So I don't think the argument is going to fly even with written motions that are going to be submitted on Saturday. The judge has already denied it, at least verbally. So I expect that the state will get its act together, supply that case law, because there's plenty of federal case law out there. You and I just looked it up on our phone while we were on a break, and I expect that motion to be denied. But you certainly want to create a good record if you're the state, because it's obviously always a potential appellate issue.
Neama, let me ask you this question. Should the prosecution have slowed it down? Do you think it was effective? Do you think the jury can react to that, basically seeing in slow motion what Wester was doing at the time he inspected her vehicle?
Terry, yes, no question. And that's why I love the Law and Crime Network, because when I first saw it in media reports, I really couldn't see the baggie. I have to confess, in Officer Wester's left hand. But, when Law and Crime slowed it down frame by frame, just like the prosecution did, you can clearly see it there. There's no denying it. It's an amazing piece of evidence for the state and really what triggered this whole investigation and criminal prosecution. So love what the prosecution did, slowing it down frame by frame. That's how I would close this case.
And that's the way you do it, and that's the way you would have done it. I'm so glad you have been here with us for most of the afternoon. Neama, I'm going to sign you off. Thank you so much.